Hello and welcome everybody. I just wanted to welcome you to our webinar number 23. Today our topic is the importance of putting real property into a trust, and our speaker is Charlie Guffey. Go ahead and start whenever you're ready.
Right. Well, thank you for having me. First off, I am a Tennessee attorney. I'm licensed in Tennessee only, so not going to be able to advise on states outside of Tennessee. Just to give a little preface on that, I have been practicing for 5 years at this point, and I do own my own firm in Tennessee. We have multiple locations here in Tennessee, and as you all know, this is estate planning is something that we do focus in with the help of the estate planning source. They are a great program to be a part of, and so happy to be here today speaking with you all. And we are going to get going. I do have a PowerPoint today that I'm happy to send out to anybody if you want to shoot me an email. My email is Charlie, CHARLIE, at charlieguffeylaw.com. That'll be at the end of the presentation too, if you want to take that down. Okay, so funding a trust, real property. So one area that we also focus in my office is real estate, which is why we are talking on both topics today, because they do go hand in hand. Very important to have a good grasp on both of those, especially if you're estate planning. The trust is only as good as the funding, is what I say. And so if you have an empty trust, that is not helpful to your client at all. So let's talk about how we will go about that, and kind of some of the basics here with trust. So the introduction is we're looking at a framework here of titling property in the name of a trust, how we need to go about it, what happens if we don't, those sorts of things. So table of contents. We do have general classifications of trust that we're going to start out with. We have types of trust in Tennessee, types of property ownership in Tennessee, benefits and potential problems, process of titling real property into a trust, but Tennessee recording statute, tax implications, and importance of professional guidance. So the first section here is general classifications of trust in Tennessee. And I know that this is pretty standard throughout the U.S. You've got the three main types, right? Revocable trust, irrevocable trust, testamentary trust. And as far as revocable trust, those are the trusts that we see that I feel like are most commonly used in my office. I'm not sure about everybody else, but very helpful for various ages. You've got anybody from a newlywed couple looking to get some basic estate planning to elderly couples that we see this be an asset for as well. And so with the revocable trust, the positives of that, just some basic things, because I know some of you have a background in this, but positives of a revocable is it is very flexible. It's amendable. It's something that we can revoke, as in the name. And so that's something that is utilized to bypass probate, but can also be done away with if it no longer serves a purpose, or if life circumstances change within the person or the couple that have the trust. So that is something that I see being most commonly used. Irrevocable trust, like I said, these are classifications. So there are different types of these trusts, but I do see irrevocable trust have perks, but also kind of has its downfall. I do see clients that are looking to get some estate planning that focuses maybe more towards on Medicaid, Medicare, protecting their assets from the nursing home, helping them qualify for the nursing home, or even some special needs situations. So that's a lot of the times when that comes into play for us in our office. Those irrevocable trust, those downfalls that I was talking about, we do have and issues sometimes of people not wanting to give up control to a trustee because, as we know, a trustor, grantor cannot be the trustee of an irrevocable trust. And so that is sometimes a turnoff for clients. And we also do have things to consider, such as Medicare, Medicaid look back periods. I know in Tennessee at this point it's 5 years. That has changed from time to time. So those different situations come up in the irrevocable trust. So it makes it maybe not a fit for everyone, quite like the revocable trust. And sometimes with that irrevocable trust as well, you run into issues of other smaller assets not being in the trust, and that may be prompting a situation of a small estate. And so those are kind of the classifications. We've also got testamentary trusts. These type of trusts you will see more so in a last will and testament. That is where the name comes from, testamentary trust. It's in a last will and testament. And it's not something that is active and alive while the person is alive, but the person who has the last will and testament, once they have passed away, they are the decedent, those testamentary trusts are going to come into effect. And those can be utilized for various things. Mainly for me, if a client is just very hesitant about getting a revocable trust or an irrevocable trust, they are more familiar with a last will and testament because that's more common language. That testamentary trust may be something that you utilize if there is a minor child that is to be a beneficiary. It's not something that really is the best way to go about things. But you will have clients that are just set on not doing a formal trust because there is the misconception that that's for the more wealthy and people who maybe have more assets than they feel like they themselves have. So sometimes that will come into play. And I do actually practice on the probate side of things as well. So I do see testamentary trust. I see them being utilized well, but then I also see them being a very big inconvenience for families. So there are two sides of the coin to that as well. So standard estate planning source trust, what we're going to go over here is just the options that the estate planning source has for trust. I know a lot of us utilize them and like to have a partnership with them. And so the basic types of trust that they offer, I know if you talk with them, they're always willing to help out in other areas, but most standard ones that we use, the single A trust, that trust is appropriate for a single individual or for a married couple who owns separate property and who does not want joint property and would like to have a separate trust for their property. So that would be when we utilize that single A trust. And I know some of these are called different things in different states, but for estate planning source purposes, this is what we're calling them. So married A trust, that is trust that is appropriate for husband and wife whose entire estate will definitely remain substantially less than one federal estate tax exclusion because of the potential impact of inflation on an estate. AB trust for a married couple is usually used even regardless of the estate size. If you're looking for something that is going to be a good tool for that married couple, that is certainly an option. A married AB trust, that's going to be appropriate for a husband and wife whose estate is less than and not expected to exceed the equivalent of 2 federal estate tax exclusions. Those trusts also are very much revocable trust, like we talked about before, amendable, easily changed, helps to bypass probate. The married Q-tip trust, that's appropriate for a husband and wife interested in preserving both federal estate tax exclusions and deferring the payments of estate taxes as long as possible when their estate exceeds or may exceed the equivalent of two federal estate tax exclusions. This trust includes the Q-tip and the Q-dot language and should be selected when one or both clients is a resident or non-citizen of the U.S. And then it can also be utilized if you do come across a situation where you have a same-sex couple who their state recognizes their marriage. I know now in the U.S. it's all across the U.S., but laws change. And so unmarried AB trust, that's appropriate for two individuals that share ownership of joint assets. Then we have the partner AA trust. That's appropriate for two individuals that wish to own assets in separate trusts. And then you can also do a single Q-tip trust, appropriate for only a husband or wife who prefer two separate trusts rather than a joint trust and who need the Q-tip provisions. So those are the main ones that we do work with the estate planning source. Okay, so as far as property ownership, we do, and like I said, I'm focusing on Tennessee because I am licensed in Tennessee, but we do have some different ways to own property. Real estate is what I'm meaning when I say property. So in Tennessee, the common types, I'm not listing every single type, but we have fee simple, and then we have remainderment interest. With the fee simple, that's how most deeds are transferred. A lot of times you will see a client come in as an individual that owns a piece of property. John Doe owns this piece of property and it's just titled in John Doe's name. That is one way to own it. We also see it owned by entities. So you've got LLCs, partnerships, businesses, those sorts of situations. They can also own in fee simple. And then you can also title it in the name of your trust, which is what we're talking about today. So another option is joint tenants with rights of survivorship. So this is going to be a situation where you may have two people, maybe siblings, I say that sometimes, want to own a piece of property together. So you've got John Doe and Jane Doe, brother and sister. They want to own property together. And their desire is if something happens to either one of them, maybe one passes before the other, then the sibling who survives them is going to own with that survivorship interest. And then we have tenancy by the entirety, very similar to joint tenants with rights of survivorship, but this is more commonly used when referring to married couples. So when a husband and a wife buys a piece of property, they're going to own it as tenants by the entirety. So they are also going to have that survivorship quality that you see in joint tenants with rights of survivorship. So if one spouse passes before the other, it is the surviving spouse's real estate. And what happens with that is a lot of people will own everything with their spouse. So you see couples who own everything together. The property, then one spouse dies, goes straight to the surviving spouse. So they don't experience probate. If their bank accounts are owned jointly, they don't experience probate. And so that surviving spouse sometimes doesn't understand the importance of getting an estate plan together. So if they didn't have one as a couple, and you have one spouse that survives the other, just because they didn't go through the probate process, they don't understand what their children are looking at having to go through, because that tenancy by the entirety has helped transfer that property, and it flow to the spouse accordingly. And that's where it's important to talk with your clients about what those effects are, because they think, since they've been through the passing of somebody, they know what it's like. Oh, it's not that big of a deal. But it's really because of situations like tenancy by the entirety, where those spouses own property together. And so they can avoid probate. Um, and then we also have the option of tenants in common. So tenants in common is a situation where you do have two people. We can use the brother and sister situation again, where you have John Doe and Jane Doe, brother and sister, who own together. And John wants his interest to go to his children, and Jane wants her interest to go to her children if they pass away. Then tenants in common is going to be a better option for them, because it would go to their heirs, whether that be their heirs at law, if they don't have an estate plan, or if it's to their beneficiaries in their will or their trust, or however they have that laid out. That tenants in common is going to allow for that. But we also have the option of a life estate in Tennessee, and what that is, and it certainly has an effect on estate planning. But what that is a lot of times we will see older people who are trying to get their affairs in order, but want the cheapest and quickest way to do it. They will come in and they'll ask for a deed, and they'll say, "I want to deed my property to my kids." But I want to reserve a life estate. And they do it because they think that they're going to be able to get around the 5-year look back period with Medicare, Medicaid, or they do it maybe to avoid probate. There's a lot of different reasons why people attempt to do it this way. One thing that I have to talk to a lot of my clients about is doing this is not the best option. I know as attorneys, we're here as advisors. I can't force someone to make a decision that's best for them, but I certainly advise you on what's best. And per my advice, I typically tell people that this is not the best route to go, just because it's cheaper to just have a deed done, because you're looking at the cost of just a deed and the recording cost of a deed versus a full estate plan. And so sometimes they think that, that's the better option. But what it does is it opens people up to issues with their children. And sometimes you could have the best children in the world, the most responsible children in the world, and you convey your property to them and you retain a life estate. And that life estate, what it does is it lets you hold an interest in the property for the length of your life. So it extinguishes upon the death of the person who has the life estate. So it's not something that carries on or passes to your heirs. It is something that is transferable. You can transfer a life estate to someone else, but the time frame of that life estate is still based on the initial person who retained the life estate. So if Jane Doe conveyed her property to her son Sam, and she retained a life estate in that, Sam's going to be the fee simple owner. She's going to have a remainderment interest as the life estate, but maybe she decides that she wants to convey her life estate to her daughter Jill. Jill then has a life estate in the property, but that life estate extinguishes upon Jane Doe's death. So it doesn't transfer to the length of Jill's life. So it is possible to transfer that, but doesn't carry over to the length of someone else's life. And so what you run into with these life estates is You will have issues of a child maybe getting in some sort of an accident. Car accident is a prime example. If you're in an accident and it's your fault, accidents happen, and maybe you don't have enough insurance coverage to take care of the damages that you caused from that accident, then that piece of property that has been mom's home for forever is up for grabs, because that is considered Sam's asset at this point. And so we run the risk of Jane Doe losing her home because she's conveyed it to her son Sam. And that is something that a lot of clients don't think about, because they do think about children having creditors. Not all of them, but some of them do. But a lot of them don't think about things like accidents. And so another issue that can arise with the life estate is with creditors. So you've got kids that may go through bankruptcy. Well, then if mom's home is that child's, that's up for grabs. That is considered an asset at that point. People can come in and put liens on your home based on your child's credit issues. And you may have a child that's perfect and doesn't have any of that, but things happen sometimes. You also have to consider divorce. I know if it is something that is commingled, and I don't practice family law when it comes to divorce and things like that, but if it is commingled and somehow Sam is paying for mom's mortgage out of marital funds, then that gets wrapped up in a divorce. And so we're looking at lots of issues that can arise with that life estate. Those are just a few examples. But these are the most common types of property ownerships that I see in Tennessee. And this is a lot of times what clients are going to have when they come in and sit down with me. And then we have to sit and brainstorm together on how to best handle their estate. And if putting it into a trust is that option for them, if they do go the route of getting a trust, then we have to look at how we're transferring this property. So there's also something that I like to consider when it comes to the property aspect of it is I do see some clients come in and they have their own business or their own LLC, and they are looking to get a trust. They're looking to get their estate planning done, but they don't want to affect their LLC. And so what will happen with that is as an LLC or, businesses, there are different types of businesses, but we're going to talk about LLCs for an example. LLCs have members. And so what you can do is, instead of being a member yourself in the LLC, you can set the LLC up to where maybe you were a member. Maybe there's 3 members and you've got Jane Doe, who's a member, John Doe, who's a member, and then you've got Sam Doe, who's a member. And maybe Jane wants to get her estate planning done. And she wants that LLC to be taken care of, her interest in the LLC. We do have the ability to make your trust, if you do a revocable trust, the owner of this. So the trust would be the member essentially. And so you would just change that by transferring the interest with an operating agreement with the Secretary of State, and handling it that way, something that your attorney should be able to help with. But the trust in essence would be a member of that LLC versus Jane Doe as an individual. So when it does come time that Jane passes, whoever the beneficiary is of that interest just can take that and kind of run with it. And it's a lot easier as far as after she's gone. Now, I will say there are certain exceptions, such as professional limited liability companies. And so that comes into play when we're talking about things like my law firm. I can't make a beneficiary of my law firm somebody who's not licensed to practice law. And so that's the rules that we have here. I know that varies per state, but that is what we're looking at here. So there are options that can get that into your state plan, but also not change the fact that the business owns the real estate or cause you to lose that limited liability protection. So most common types of deeds in Tennessee, we do typically use 3 types of deeds here. I know it's different in other areas. I know back a few months ago when we were all in a conference in Pigeon Forge, we talked a little bit about Florida's typical deeds, but in Tennessee, the main ones that we see used are general warranty deed, special warranty deed, and a quitclaim deed. So that general warranty deed, that is typically used when property is bought and sold, when money is exchanged for property. And so if Jane Doe sold her property to John Doe, a general warranty deed would be the type of deed that you typically use just because money would change hands. And what comes with that is you do have the seller of the property warranting good title, marketable title. And so that's what that general warranty means. Now, when you are warranting that, that means, as far as you're aware, to the best of your knowledge, you are conveying property that has good, clear title and doesn't have defects, encumbrances, those sorts of things, unless they have been previously disclosed. And a lot of times, if you're going through a law firm or a title company, they're going to work to clear those encumbrances or those title defects. But with that comes kind of a downfall or a negative side is transfer taxes. So when this deed does go to the Register of Deeds office to be recorded, this type of deed is going to cause the buyer to pay transfer taxes. And what that is an amount that the buyer of the property is going to have to give to the deeds office that they either gave for the property or what the fair market value is. And they do have to list this on the deed. It has to be signed under oath. And then that number is used to calculate transfer taxes before the deed can get recorded. So that does become costly sometimes, which is not ideal for a lot of people if it's a family situation, if no money's being exchanged, that sort of things. Or if you are transferring property into your trust, no money's being exchanged for that. So a general warranty deed is probably not the best type to use for that. Now, a special warranty deed, that is something that's seen a little bit less often. The special warranty deed, what that is we are warranting, the seller's warranting to a certain extent. It is a limited warranty. The seller guarantees that the property is free of title defects that occurred while they owned the property. They are not warranting it in general, like the general warranty deed is. They are just warranting it for their ownership of the property. So that is something that is seen from time to time, but not used quite as often as the general warranty or the quitclaim deed. But this also does prompt those transfer taxes that we talked about. We also have the option of the quitclaim deed. Quitclaim deed is the deed that is usually used when transferring property into a trust. That will not require the transfer taxes. The buyer, seller, or just if you're conveying it from yourself to your trust, you don't have to report that. So that is why it's most commonly used is that quitclaim deed. The deal with a quitclaim deed, though, is very much the fact that there is no warranty with this. So it's good when you're using it to transfer property into trust because essentially you're conveying it from yourself to your trust. So it's not changing hands drastically. But if we are buying and selling, quitclaim deed's not necessarily the best route to take because there is no warranty of good title on that. You're just saying, I convey any interest that I may have in the property. So essentially, we could have Sarah Doe out here who has no interest in a piece of property convey to Jane Doe a quitclaim deed. Well, she has no interest. She's just conveying all the interest she has, which is none. But so that can be used to cause problems sometimes. However, in the situation of estate planning, I do think it is the best route to take is to use that quitclaim deed. Okay, benefits and potential problems of titling or not titling real property in a trust. So benefits that we see of titling property in a trust, some of these have been mentioned already, but it does avoid probate in Tennessee. So if you have a revocable trust and you pass away, your children can then step in and use your trust to disperse your assets to your beneficiaries the way that you have named them, if the trust is funded properly, which is why we've been talking about real estate and how we get that real estate into a trust. I have seen issues where people will have a trust. They have maybe put one piece of property in it, and then they forgot a few years later that they had this trust, purchased another piece of property, and put it in their name as an individual. At that point, your children's still going to have to go through probate, or your heirs, whoever's handling your estate, still going to have to go through probate because that one piece of property was not in the trust. And so that definitely poses an issue if we're not funding these trusts. One thing I tell my clients when I meet with them is, if you buy a piece of property anywhere, out of state, in state, please just let me know. The good thing about my office is we do handle title as well, so I can handle those closings if they decide to purchase in Tennessee. But sometimes I have clients who want a beach house in Florida, and they purchase a home down there. And I just stress the importance to them that if you do something like that, if you purchase a vacation home in another state, please just let me know, because I will step in and assist you with tracking down an attorney in that state so that you can get a deed drafted to put that property in your trust, so your kids are not having to go through probate. And what happens in that situation is, and it's something I'm dealing with, a very similar situation right now, is maybe you have your trust and it's completely funded with your real estate in Tennessee, but maybe you do get that beach house in Florida and you leave that beach house out. Well, in order to, if you're still a resident in Tennessee, in order to get the Florida probate open, you have to also open a probate in Tennessee. So we're looking at prompting two probates still, even with having a trust and having all Tennessee property in a trust, just because we didn't put the beach house in the trust. And so what that would be called in Florida would be an ancillary probate. And in order to open an ancillary, you do have to open a probate in the domicile state or the residential state of the person who has passed away. And so that poses a lot of issues too, because you're looking at two probates there and you've not saved your children or your heirs any money or any headache. And unfortunately, that is something that we don't want to see, but is very well a possibility if you don't get that property transferred properly. The simplified transfer of ownership. So once again, that's just making it much easier than having to go through the probate process. We also see possible tax benefits. That's something that I always direct people to talk to their CPA about. And I'm certainly not going to touch on it here because I know even Tennessee's taxes are very different from other states. So depending on the state you're in, talk to your attorney, talk to your accountant. There are some possible tax benefits for your estate. And then the beneficiary protection. So that is just assisting. I mean, that can assist in many different ways. One way that can assist is if you have a child that is special needs. We see that pop up sometimes, and you still want to leave them something, but you can't leave it outright to them, right? So if we set up the appropriate revocable trust, then we do have the ability to leave that to a child in a special needs trust. So you are protecting your beneficiaries in that aspect where your child's not looking to lose their government assistance because you left them something that you shouldn't have left them, or you left it to them in a way that shouldn't have been left to them. Asset protection, sometimes we do have the ability to utilize irrevocable type trust for that asset protection. Like I had mentioned earlier, I do have a lot of clients come see me with concerns of Medicare, Medicaid taking their home. That's the way that they always phrase it when they come in. And like I said, Tennessee has a 5-year look back period. So if we do get somebody who is very proactive on that end of things and they're planning early, we do have the ability to assist them with that, and ensure that their kids are able to inherit their home instead of a lien being placed on their home during the probate process or during their passing for any nursing home care that they have received. Incapacity. So, I also see people who don't have estate plans together, a lot of issues with incapacity. A lot of times they'll come to me when it's too late with that. And they will, want help with it, but they don't want to go through the costly and time-consuming process of getting a conservatorship. And if you don't have some of these things like a power of attorney and a trust in place where that trustee can step in and manage those assets for mom and dad, then you are looking at having to go through a court process of getting a conservatorship, which is long and frustrating and expensive. And, there may still be circumstances where you still need a conservatorship. But for the most part, if you do really good estate planning, that's something that you can definitely push out for as long as possible, if not completely avoid altogether. Cons of titling the real property in a trust. You do have clients with the potential loss of control. We mentioned that earlier about the irrevocable trust. You've got, a little more complex process. You've got the maintenance of it. It's costly up front when it comes to handling trust. I know that's the biggest withdrawal from my clients that I see is when you start talking about the cost of it. A lot of them don't want to pay that cost up front to get a trust done, and it is more expensive to do a trust rather than just a basic last will and testament. But at the end of the day, I try to let them know that this is going to save their kids or their heirs in the long run if it is handled properly, funded properly, like we've been talking about. It's going to save them from the costly process of a probate. And sometimes that will kind of sink in for clients. Other times it's just not a decision they're going to make, and they will, end up making the decision to not do a trust at the end of the day because of that cost. But I do try to encourage them that it does save them in the long run. And as far as the maintenance goes, that's something we just mentioned. Buying and selling property, you just got to maintain that funding, make sure it's up to date. Potential problems of not titling property in a trust. So we've got the property must pass through probate. Talked about that. It's a lengthy and expensive process. And I know every state handles probate differently, but I haven't found one state yet that says it's a cheap and short process. So I think that's something that can relate on any level there. Failure to transfer assets as intended. So If there's no estate plan in place, property will follow intestate succession. And sometimes that causes more problems than people think it does. And when you don't see that on the back end, on the probate side of it, sometimes it's overlooked. But an example of that is Jane being estranged from her two sons. She wanted her property to pass to her sister Jill, but did not have an estate planning done, and so her property passes to her two sons, whether that was her intentions or not. Um, and I've had so many situations where that comes into play. Had a situation in a probate where child hadn't been in contact with father really their whole life. The child was the decedent, and child just thought property would go to her mother because she had no children, no issue. She just assumed, but dad was on that birth certificate. He hadn't been involved in her life, but he was still there. He was still identified. His rights hadn't been taken away or signed away. And so then you're looking at having to track dad down if he is still alive. And then we're going through this big, long process that just a good estate plan would have fixed. That would have helped us avoid so much. Tax implications, like we said, it's dependent on your state. I would talk with your CPA about that. Then we've got no asset protection. You do have creditor claims, lawsuits, like we talked about, car accidents, bankruptcies, divorce. We do have the 10-care look back period, or Medicaid, Medicare is what I've been referring to it as. Loss of privacy. This is something I really hit with my clients, especially in smaller areas. I know that in bigger areas, a lot of times the privacy is not a huge thing because there are so many probates coming and going. But in some of the smaller areas, that's public record. And when everybody knows everybody in the town, that's a problem, right? You don't want your private assets to be made public for everybody in town to know what's going on. And so a lot of times that is a good selling point for clients, is the privacy. They really don't think about that and about how the probate process is very public. So, transferring that real estate into their trust, letting it pass that way, that's going to give them that privacy that they desire. And then no beneficiary protection. There's failure to shield the property from creditors, and higher tax burden, sometimes loss of tax benefits, delays in distribution. That's a big one that we see. And then family disputes. Man, that happens more often than you think. People think sometimes that their kids have great relationships, and then they come in and just can't get along about anything. And death changes people. That's what I always say to my clients. You don't know how people are going to react, how they're going to grieve, and having a good estate plan in place, having it properly funded, that just makes it easier for everybody. It makes the grieving process so much easier, especially when it comes to a trust, because the children or the heirs are not having to rush to get all these things changed over or rush to get probate open, because they have that time to grieve, because they have that good estate plan that mom and dad did. Process of titling the real property in a trust. So we've talked about the deeds, we've talked about the vehicles to use. We'll talk about titling the property in a trust. So creating a valid trust. Obviously, that's something that has to be done. Identifying the properties. Like I said, don't forget those out-of-state vacation homes that you have maybe purchased, or your clients have purchased. Got to include all of those, not just the ones that you live in, not just home, your domicile. Got to include all of those, even if it is just an empty lot somewhere. I see clients sometimes that are wheeling and dealing and maybe work in real estate and they have empty lots. Those empty lots included. Let's put those in. And that way we can avoid probate on that. Conveying property via a new deed. So it doesn't just magically appear in the trust. I have had clients come to me that had trust done elsewhere. It was never funded. They thought their real estate was put into that trust, and at the end of the day, it was not put into that trust because there was no new deed drafted. And so, drafting that new deed and recording that deed, that is also something that's super, super important. And we'll talk about that a little bit later, a little bit further. So an estate, the TCA is down there, the statute, an estate in real property may be acquired in the name of the trust or in the name of the trustee on behalf of the named trust. And title to real property conveyed by the trust must be conveyed by the trustee as the trustee of the trust. So the person signing, if you do put that property into your trust and you decide to sell it, the person signing to sell it is that trustee, whether that be the trustor or that be someone else. Titling the property in a trust, consider the following questions. Who do you want the property to go to? Do you want to specifically bequest the property, quitclaim deed, warranty deed? Is there a mortgage on the property? That's something that comes into play a lot with irrevocable trust. You got to talk to mortgage companies first. We're not looking at having any issues with mortgages, because if you do transfer property that has a mortgage on it and the mortgage company doesn't okay it, and the trustee is not the same person as the trustor or the person on the mortgage, then you've got an issue, because a lot of those have a due and payable clause, and that clause can force that mortgage to become due and payable immediately because of that one transfer. So super important to be conscious of that. Do you want to force liquidation of the property? Any current life estates? Do you wish to have one? Is Medicaid eligibility a concern? So lots of questions to think about there. Tennessee recording statute. Every state is different on this. Tennessee is a race notice, a race notice state. And so what that means is if there's a deed dispute, such as a wild deed, then the first deed recorded in the registrar's office has the superior claim of title. The wild deed, a legal document that transfers ownership of property but is considered defective. So, if you have a deed out here that maybe mom has gotten a little dementia and she deeded her property to this trust, the trust attorney gave the deed to her and said, go record this deed. And then she gets dementia after that. And early stages of dementia, she still has capacity to sign, but she forgets that she signed 5-10 years ago to put this deed into the trust. Maybe she executes another deed to her children just outright. Then we've got 2 deeds floating around for this one piece of property because the first deed wasn't recorded. And so in order to hold superior title to other conflicting claims to real property, a grantee must be the first to record their deed and be a purchaser for value without notice of any prior existing superior claims. So what I just do to fix this is my office just records the deeds. I make sure the deed's recorded, so I'm not putting it in the hands of a client and saying, oh, you take that and record it. Some law offices do, some title companies do. I don't do that because we are a race notice state. And if a deed doesn't get recorded and nobody is on notice of that transfer, then another deed that is executed could be found to be a valid deed. And so, like I said, it's not applicable to all states. I would talk to your local attorney if that is something that you have a concern about or would like to know more about. Issues can occur when the new deed is not recorded in the registrar's office and cannot be found at the time of death, thus prompting probate. So that's another issue that can occur. If that deed is not recorded and your children can't find it, even if you have a trust, your trust isn't funded because we have to have the original of the deed to record. Copies don't work. None of that work. Like we have to have the original. So that's the importance of professional assistance, right? Is having an attorney who is going to say, hey, no, we're just going to go ahead and take care of that for you. Prevent the possibility of the client not following through with the recording. Don't put that in the client's hands. So there's our Tennessee state statute on that, if you'd like to look into it a little bit further. Tax implications. Now, like I said, this is not applicable to everyone. Do talk to your CPA, but you've got gift or inheritance taxes, state dependent. That doesn't apply to us in Tennessee. There is a lifetime gift tax exemption up to 13.61 million. So that's something that I don't often have to deal with because most of the states that I see are under that. Property taxes now doesn't change simply because of the transfer. However, if you do have clients that have lots of farmland that may be under a green belt, that can cause a change. It is going to have to be re-registered as a greenbelt property in order to get those greenbelt benefits. So that is something to think about if you're dealing with a client that has large amounts of real estate or farmland or something like that. Professional guidance, importance of professional guidance, ensuring legal compliance, avoiding common pitfalls and mistakes, maximizing asset protection, handling complex assets, updating the trust, special considerations, minimizing estate and gift taxes, recording deeds. That's all things that we have discussed today. So those are importance of the professional guidance and not trying to just do this out here on your own or using AI or using Google. All of these things are things that you're going to benefit from by using a professional. So any questions regarding our presentation today? All right. Well, if there are no other questions, I am going to thank you all for allowing me to speak. And there is my contact information. Like I said, if you are looking for copies of those slides, we're happy to send that over to you. But it's going to be my email address.
Perfect. We do have one comment from Jeff. He says, great information. Thanks for covering it. And then we'll give it a moment here. Sometimes there's a slight delay on when it's posted just in case somebody has a question. But I do want to take the time and thank you for speaking today and thank everybody for joining us.
Absolutely. Thank you for having me.
Sorry, I'm watching it on the screen over here, so it just went to the question site. So we'll just give it another minute here. It doesn't look like we have any questions. So thank you again, everyone, for joining.
Good deal. Thank you.